afternoon, everyone, and welcome. Welcome to Hofstra. And for those of you who are returning, we welcome you home to Hofstra. And the ones who already, as I say, live here, we're happy at Hofstra. And welcome to a very special lecture this afternoon. It's my pleasure as the Interim Dean of Hofstra Law to introduce to you our very own Howard Lichtenstein, Professor of Legal Ethics and the Director of our Monroe Friedman Institute for the Study of Legal Ethics. I like to refer to her as one in a billion. Hofstra is the beneficiary of her many talents, and that is our very own Professor, Ellen Yaroshevsky. Professor Yaroshevsky teaches ethics courses as well as criminal procedure and organizes more events than anybody else I know here at Hofstra. Not only does she lecture and write and concentrate on issues in legal ethics, but also with a concentration on our criminal justice system. I could go on and tell you about all the awards that she has won and all the recognition that she has received. But what I think is essential that you do know is from 1994 to 2016, prior to coming to Hofstra, which was one of the best decisions she's ever made, she was a clinical professor of law and the director of the Jacob Burns Center for Ethics in the Practice of Law at the Benjamin N. Cardozo School of Law in New York. And prior to being on the Cardozo faculty, she was an attorney who concentrated on constitutional rights in private practice. As I said, if you look at her bio, the awards are absolutely incredible. I just mentioned one recent award, which was the Outstanding Contribution in the Field of Criminal Law from the New York State Bar Association, a very prestigious award. But to me, she is, and I hope to you, not only a fabulous professor, not only a fabulous teacher and mentor, but absolutely fabulous person. So it is my pleasure to introduce Professor Yaroshevsky.
Thank you so much. It's really an over-the-top, gracious introduction. But if I'm one in a billion, this is one in a trillion. So I'm so delighted. This is my inaugural Howard Lichtenstein lecture. This is the first time I've sponsored this at Hofstra Law School. So before I introduce our terrific speaker, Andrew Perlman, let me just tell you a little bit about Howard Lichtenstein. Howard Lichtenstein was a labor lawyer who was an expert in administrative law. And so for some 44 years, he worked as a labor lawyer at the firm of Proskauer Rose. He was really committed to legal ethics and to legal education. And so when Hofstra was founded, he, along with others, decided to sponsor a professorship, and then as a result of that, this lecture. This lecture began in 1991, and we have had the country's most distinguished legal ethicists come and speak to people at Hofstra Law School. So when I came here, I thought, who do I want? Who is the person, I think, and now in the field of legal ethics, who's doing the most engaging, innovative, and exciting work? And there's nobody better in my mind than Dean Andrew Perlman, and I was delighted and honored when he accepted the invitation to come here. He'll be here today, he'll be here tomorrow as well at a matrimonial summit. So let me just tell you a little about him. You should Google him. I want to just tell you, if you go online and you see what people have said about him when he became the dean at Suffolk in August of 2015, there's just a level of excitement about who he is, both as a teacher, as a scholar, but as an innovator in legal ethics that just pervades all of the PR, as he would call it, online about him. I've known Andy for a number of years because we're both in the field of legal ethics, and he is perhaps the most innovative person who has a vision, and he's called a visionary, about what the future of this legal profession looks like and should look like. So he talks about technology, as you'll hear today. He talks about innovation, and he talks about globalization. Those are all of the reasons that at Suffolk County that at Suffolk Law School that they enjoyed so much, the idea that someone who taught civil procedure, who taught legal ethics, who wrote a textbook on civil procedure, a textbook on legal ethics that those of you who are in my class we use his textbook, right? That among the reasons they decided he'd be perfect for this period of time going forward to look at the future of legal education. Andy's won a number of awards, but I just want to talk to you about some of the work he's done in the profession that's so significant. The American Bar Association created various commissions. One of them is a new one, the Center on Innovation. He's the chair of that. Before that, there's the ABA Commission on what we call in my field Ethics 2020, it was years ago, looking forward to say, what kind of rules and regulations do we need in 2020? He was the chief reporter. He brought notions of technology and globalization to the current rules that we have, to the current conversations around the country about the way in which we should regulate lawyers and what are the concerns about the profession going forward. On top of that, I don't know how he does all this in his spare time, but he has a deep commitment to access to legal services for people who can't afford it. And so among the things he's done in the last few years is traveled around the country holding hearings where many people come and testify about the ways in which legal services should be offered to people. What kind of rules should we create? What kind of regulations? So he's just done so many things. Now, I can talk about him personally, but I have to tell you, I want him to have time to talk. In addition to people saying he's creative, he's practical, he's a visionary for the future of the profession, he executes with clarity and precision, he leads law schools in a way that prepares grads to be innovative, highly successful, and a valued counselor to their clients. I can think of no better accolade for any professor or any dean. But I have to tell you on top of that, he was the law professor for some of your favorite professors here. So Professor Sample was Dean Perlman's student in his first year of teaching. Professor Ostro was Professor Perlman's. He doesn't even look old enough to be their teacher, but he actually was. And Jen Gunlack, Professor Gunlack, taught with Professor Perlman at Suffolk for many years. My final point is one of the things I loved and appreciate most about Professor Perlman, Dean Perlman, is when Google decided we want to test out new technology for professors, they developed something you may have heard of called Google Glass. And they picked, what is Google Glass? Believe it or not, professors stand up there with their glasses on with a little computer, right, as part of their glasses, and somehow I could never understand this, but you could see your computer at the same time that you're looking out and teaching. Who did they pick? Who did they pick as a person around the country with whom they would go? And try Google Glass, Professor Perlman. So we're so delighted you're here, and thank you so much.
Thank you for those extremely generous remarks. Excessively generous, but I appreciate it. I'll take them. I am so grateful to be here and be giving the Lichtenstein lecture. So many of my mentors, people I look up to, have given this lecture over the years, and it is a real honor to be giving this lecture myself. I want to acknowledge a few people who are here. I'm especially grateful who heard those remarks. First of all, my aunt, Arlene Kashkin, is here. She lives nearby. And notably, her son attended this very fine law school and is a successful criminal defense lawyer. Her partner, Don Sadowski, is also here. Thank you for coming. My stepfather, Louis Werbolowski, is here. Thank you very much for being here. And the final person I want to acknowledge, and I'm especially grateful she heard all of those wonderful things about me, is the person who, quite literally, I would not be here without her. And she gave me all of the support that I needed to achieve the various things that I've achieved throughout my life and my career, and that's my mother, Beverly Perlman. Thank you. it adds to the pressure of giving a lecture when your mother is in the room. So pretend that you're enjoying it, even if you're not. So I'm giving a presentation about the future of the legal profession. But I think in order to do that, we need to first understand where we've come from, the history of the legal profession, and what the delivery of legal services looked like, let's say, 100 years ago. Here is a picture that I think nicely captures it. I think. There we go. This. Couple guys, typically older guys, typically white older guys, sitting around a table with some books on the shelves, shuffling some papers. This is the image that we have of what legal services looked like many years ago, and it's pretty close to accurate. And there are certain words that would come to mind when we think of law practice in the past. Books, physical offices, lawyer generalists, the idea that people handled anything that came through the door. There was not much specialization, and they handled it from soup to nuts. They didn't have the opportunity to delegate tasks to other people in their firms. They tended to handle it all themselves. When we think about law practice today, an entirely new vocabulary comes to mind. New words, new knowledge, new skills, a new way of doing things that I think can best be characterized by two words, and those words are rapid change. Now, in light of that rapid change, here's a question that I often consider. That is, what new competencies do lawyers need to have today that they didn't need 20 years or so ago when I graduated from law school? And here is where I've been able to do some work, and Ellen referenced the ABA's Commission on Ethics 2020 that added some new language to a comment to Rule 1.1, which, for those of you who have taken professional responsibility, will know that's the duty of competence. And the new language that was added is underlined on the screen. The idea is that lawyers not only must keep abreast of changes in law and its practice, but that this necessarily includes understanding the benefits and risks associated with relevant technology. This was the first time that the word technology ever appeared in the Model Rules of Professional Conduct, and it was a very conscious decision to place those words in the context of a lawyer's duty of competence. So in the few years since that change to Rule 1.1, 27 jurisdictions have adopted that language or something very close to it, including New York. So now we have, embedded in the rules of professional conduct, the notion that lawyers, in order to remain competent, have to understand the benefits and risks associated with relevant technology. So here's the question. What is the typical lawyer reaction? I am a law professor by training, so I like to ask multiple choice questions. I will give you two possible answers. So, is the answer to this question somebody that looks like this? Now, you heard me talk about Google Glass. This is pretty close. Anybody just trivia question about who this is and what the context is? Jean-Luc Picard, when he was forced by the board to equip himself with technology, and the phrase that was often muttered was, "Resistance is futile." Is this the reaction that lawyers have? Resistance is futile. They embrace technology as they become one with technology. Or is the typical reaction something that looks more like this? Like this. That. With lawyers' heads in the sand. And for the most part, this, more often than not, is what the typical reaction is. The question I struggle with as a lawyer who wants to see the profession move forward, who wants to see lawyers embrace technology for the benefit of clients and the public, why is it that our profession tends to be so slow in adopting new ways of doing things? And here is where I am going to blame myself, or at least symbolically myself, that is blame law schools. I think law schools do not do a particularly good job of preparing future lawyers for the profession they are about to enter. So let me take you back in time once again to what legal education looked like during that first slide I had up on the screen. This man, Christopher Columbus Langdell, pioneered a new approach to legal education at Harvard a little over 100 years ago. prior to Christopher Columbus Langell coming on the scene, the way that lawyers learned and prepared for the profession, if they went to law school at all, because you could apprentice and gain access to the profession that way. But if you went to law school, you simply read treatises. You read descriptions of what the law was. Langell came up with a new approach. He said, why don't we have students read primary sources, and in particular, legal opinions, and be able to extract from those opinions basic legal principles, and then apply those principles to a set of facts that students had not seen before. This is called the case method of legal instruction, and it's spread throughout the country to essentially every law school. Now, a lot has changed, as we know, since Christopher Columbus Langell did his work. So what does legal education look like today? Well, I would suggest to you, it looks a lot like it did over 100 years ago. It's still very Langellian. For those of you who recognize the description of reading a case, extracting from the case a basic legal principle, and applying it to a set of facts you've never seen before, we still do that. Now, I want to be fair to law schools. After all, I'm the dean of one. And we have modernized legal education in a variety of ways. We have pushed Langell off to the side. And we have added certainly new subject areas, new doctrinal courses reflecting changes in society. More importantly, we've added new skills. We've added more clinical instruction, and Professor Yaroshevsky has been a leader in the clinical education movement for quite some time. We've added more training in legal writing. All important developments. But at the end of the day, the reality is law school and legal education is still inherently backwards looking. We look to precedents. We look to the way things were done in the past rather than to the future about how legal services will be delivered in the coming years. So I'm fond of a quote attributed to Wayne Gretzky. And a legal futurist named Richard Susskind quotes Wayne Gretzky this way. So this is me quoting Richard Susskind, quoting Wayne Gretzky, who has said, skate to where the puck's going, not where it is. Now, I think that's really good advice for hockey players, but I would also suggest that it's really good advice for lawyers and law schools. So the question that we have to struggle with, where is the puck going for the delivery of legal services? And here is the answer, suggested by Richard Susskind, and with which I wholeheartedly agree. So these are the new competencies, and what I want to focus on is new law. That is, the puck is moving in the direction of all of these new competencies, and among them, the most important are the ones relating to delivery of legal services in new ways. So here's the chart that Richard Susskind came up with. He is from the UK. I've kept his British spelling, so bear with me. So let me explain what this is all about. On the left side, you see the word bespoke. How many of you know what the word bespoke means? Only a few people. It's kind of a distinctly British word, but let me tell you what it is. Bespoke means highly tailored and customized, unique to the individual. So the classic example of bespoke is if you buy a bespoke suit. That is, the tailor takes your measurements exactly to your specifications and creates a suit that is meant for you and you alone. It suffices to say, unfortunately, this is not a bespoke suit. I got this, I don't know, at Marshall's or something like that. But it's not bespoke. Bespoke is specific to the individual. Now, legal services can also be bespoke. Bespoke in the sense, client comes in, you are preparing services for that individual, unique circumstances, each time from scratch, and it is custom tailored. That's a bespoke legal service. Now, over time, aspects of legal services can become standardized, so you don't have to go through that same mechanism every time a new client comes in the door. So you can get certain standardized phrases or clauses that you might put either in a contract document or a litigation document. So certain features of legal services can become standardized. Eventually, the service can become so standardized that you can create documents in a very systematic way. So you're not just merely repeating certain phrases and clauses, but you can generate entire documents by simply filling in some forms. Eventually, you can turn that around, make it available to the public to purchase on their own with very little involvement from the lawyer, And at some point, that legal service becomes so easy to produce that the public can get it in effectively a commoditized way for free. There's no money really to be made for lawyers in that area anymore. Let me give you an example of a service that has gone through this transition. Let's take basic wills, and we'll start at 1980. Back then, if you were going to go get a will, it was a largely bespoke undertaking. You would walk in to a lawyer's office. The lawyer would ask you a number of questions, would draft up a will, review it with you, maybe make some changes. There may have been some standardized features, certain clauses and phrases and provisions that you would find in just about any will in a particular jurisdiction, but it was still largely a bespoke undertaking. Now, if you fast forward and we think about what does it look like today, in 2017, we are largely at commoditized basic wills. That is, if you want a basic will, you can go online, answer a number of questions, and get that service at an extremely low cost relative to what it would have cost you many years ago. And if you think more generally about transactional services, what we see is a splintering of the marketplace. That is where some services are at the bespoke level, but you see other kinds of transactional work taking place at other points along the way. So let me give you some examples. A commoditized transaction. If you are going to incorporate a small business, that is effectively no cost. You can go on a government website, you can get the forms, you can fill them out yourselves. It is very easy to do. If you are a lawyer and your business, your practice is all about incorporating small businesses, you might want to consider finding another area of work because that one is not going to generate much revenue for you in the future. Moving along to packaged legal services. The classic packaged legal service provider is Legalzoom. They take technology, they are providing a service, they are developing all of the questions and answers for the questions that the public can answer, and for a fee generating that document. So it's taking the service, packaging it to the public for a fee, driving down the cost of various kinds of transactional services. The leading provider of incorporation in California right now is Legalzoom, and it's not even close. They are dominating in packaged legal services of various kinds of transactions. Systematized. If you've ever gotten a home mortgage or refinanced, you'll have a lawyer who shows up at your home, or you go to the lawyer's office and you get a stack of papers. There's not somebody at a computer typing up each and every page of those documents. Those documents are generated in a systematized way using technology, using the basic information that's imported, and you can spit it out in a systematized way. That's the only way that you can actually make any money in home closings. Now, plenty of people do, and if they have the right technology, there's still a lot of money to be made there, but it is largely a systematized approach. At the end of the day, though, law schools, most lawyers, we're all focused over here. We're still thinking about delivering legal services in a bespoke way because that's how we've been trained. That's a mistake, because the market is quickly moving along these other points along the way. If you, as future lawyers or as current lawyers, can learn to deliver legal services using technology at other points along the spectrum, you will, in very short order, come out ahead of your competition and be much more successful. And I can give you lots of examples of that I've seen around the country. And it's not true just of transactional documents. It's also true of dispute resolution. Once again, in by dispute resolution, I mean this very broadly, to include litigation of various kinds, including dispute resolution outside of court. Let me give you an example of a commoditized dispute resolution service. There's a company called Modria. How many of you have heard of Modria? Okay, just a couple of you, and it's not uncommon to only see a couple of hands go up. But here's what's remarkable. Modria resolves more disputes in the United States than the entire U.S. court system combined, and nobody knows of them. It's pretty remarkable that there would be a company that is so involved in resolving disputes that a room full of law students and people in the legal industry don't know who they are. So let me tell you who they are. Modria is the platform developed for eBay and PayPal to resolve disputes between customers who use the service. I'll give you an example because I had this happen. I bought a television and received a Best Buy gift card. I wasn't planning on going to Best Buy, so I decided to put it up on eBay. Somebody bought it, I received the payment electronically, and then I put the Best Buy gift card in an envelope and I sent it to the buyer. A week later, the buyer says, I never received it. I don't know what you're talking about. I put it in the mail, and the person said, I want my money back. Well, we've got a little bit of a problem. Because after I did some research, it turns out the gift card had been used. So how do we resolve it? Well, I'm not going to go to small claims court. That doesn't make any sense. The person lived in Canada. And so the only way we could, there's no way that eBay has the human resources to resolve small-level disputes like this in a bespoke manner. So what Modria was a technology platform that sits on eBay and PayPal and resolves disputes of this kind. And what you see happen is a series of questions and answers that are posed to the people who have a dispute. The question that was asked of me was, did I have a return receipt? The answer was no, because I was a fool and put the gift card in an envelope and just mailed it off. I had no confirmation that it had been received. Now, according to the terms and conditions on eBay's website, which I could have read if I had bothered to do it, I was supposed to get a return receipt for exactly this reason, in case somebody called me out on it. So at the end of the day, I lost the dispute. Now, I can tell you, as a former litigator, this was infuriating. I wasn't pleased at the outcome in that regard, but at the same time, I thought it was fair. It was fair. If I couldn't prove that I sent this out and that it had been received, I'm the one who should bear the associated cost. Now, Modria is doing this not only for eBay and PayPal, but providing a lot of other services as well throughout the country and the world. And court systems are moving in this direction. So I'll give you an example right here in New York. New York is developing a pilot project for consumer debt cases to resolve them online. It's the very early stages of development, but it's this idea of trying to resolve disputes and driving down the cost as much as possible to the benefit of consumers. Okay, so packaged, if you walk into some courthouses, you'll see kiosks. This is the idea of turning around court services, making them available to the public using technology. And there are other examples as well. Systematized dispute resolution services. You can generate complaints, responses to interrogatories. You can do document requests in a systematized way using technology. But at the end of the day, and I've taught civil procedure, so I know this well, I'm still, for the most part, we're teaching future lawyers how to deliver dispute resolution services in a bespoke manner. Okay. On top of all of this, bespoke legal services themselves are now under threat through increasingly sophisticated artificial intelligence. Great example here, you may have heard of IBM Watson, which got so sophisticated that it can now beat the best Jeopardy champions ever. And just think about how remarkable the AI has to be to listen to a question, understand what it means in a Jeopardy-style format, and beat the best Jeopardy champions in the world. That's how sophisticated AI is becoming. And if AI can do that, it's not too much of a stretch to think that there might be some legal applications. One company that's developed a solution in the legal research context using AI is a company called Ross Intelligence. And if you were looking and reading the news just last week, you'll have seen this report. It was literally the end of February. J.P. Morgan has developed a software solution that, in a particular context of financial deals, that kept legal teams busy for thousands of hours can now take seconds. Seconds. So what does that mean for the future of bespoke services? We are facing a very significant change in how legal services are going to be delivered in the future. So to compete, to serve the public effectively, we need to think outside that bespoke box. We need to understand how to deliver legal services in new ways. Now, how can we do that? For those of you who are still in law school, there's still time, and I want you to understand how law firms are responding. Because if you're going into a firm, whether it's a small firm or up to a large one, you'll be better prepared if you understand some of these new concepts. Legal project management and process improvement techniques. These are concepts from the business world that have been employed in any number of ways to drive down the cost of various kinds of production and services. It's now coming to law. Law firms now have legal project management departments. They are mapping the processes of how various legal services are delivered, and they are finding ways to use either technology or people in ways that make that service more affordable. At the same time, law firms are also automating the creation of documents in much the way that Legalzoom does, but they're doing it in-house. They have expert system tools where the lawyers are providing the substantive knowledge, and through questions and answers you can find the information you're looking for. So imagine you're a company and you have human resources department and you want to know whether somebody is an employee or an independent contractor. Through a series of questions and answers, with lawyers providing the substance, you can quickly find out the information without picking up the phone, without speaking with a lawyer. An expert system tool can be created by law firms to generate that kind of service. Legal process outsourcing. So law firms that don't have the capacity to develop the technology themselves are sometimes outsourcing it to an increasing variety of companies that have that ability to provide that service. And some law firms, an increasing number of them as I'm talking to firms, are moving away from the billable hour. Instead of billing about a tenth of an hour, you go to AFAs, which is known as alternative fee arrangements. And the benefit of doing that is it creates a much stronger incentive for lawyers and law firms to find better ways, more efficient ways to deliver their services. Because think about what it means if you're a law firm billing your services almost entirely by the hour. What incentive do you have to do the work more efficiently? Because at the end of the day, it will make you less money if you are more efficient. By using AFAs, it creates a different kind of incentive that I think will produce more efficiency in the long run. So those are some of the law firm responses. And larger law firms are really embracing this, creating research and development departments within their law firms. This is something that you would put in the realm of science or pharmaceutical companies, right? Research and development. Law firms are investing in research and development to create solutions that will help their lawyers deliver the services more efficiently and become more competitive. In-house legal departments are doing the same. The Corporate Legal Operations Consortium, called CLOC, was just created within the last year or so. Legal operations is becoming a huge area. I think I said huge. I apologize. A huge, with an H, area inside of legal departments, and they're using legal process outsourcers, and they are focused on legal project management and process improvement. So lawyers who want to do work for companies better be aware of how the clients are changing their expectations as well. Responses by law schools. So even though I made a little bit of fun of law schools for not doing much to change, and a task force on the future of legal education reached a similar conclusion, saying that changes in the delivery of legal services and law-related technology are important. Only a modest number of law schools currently include developing this competence as part of the curriculum. Now, fortunately, it may be modest, but it is growing. And I'll note two schools on this list that I think we should be proud of. Of course, one being Hofstra, and the other one is my own law school, Suffolk. So here at Hofstra, as many of you might know, you have a law, logic, and technology research laboratory that is really trying to push the ball forward in this regard. At Suffolk, we have an institute on law practice technology and innovation that is trying to do the same thing. We have a concentration in the area where we're teaching students legal project management, process improvement, legal design. We're trying to teach them about automated document assembly and expert system tools, and it's paying off. Our students are getting new kinds of internships in legal project management, areas like knowledge management, and it's leading to some pretty cool results. So here's a story of a relatively recent graduate who went through our concentration. So as we created this program, I got a call from a law firm in Seattle. Right, so Suffolk is in Boston, although, by the way, Ellen said Suffolk County. I can't tell you when I'm on the road how many people think Suffolk Law School is on Long Island because of Suffolk County. We're not. We're in Boston. So Seattle Seattle-based law firm, reached out to me, this was before I became dean when I was the director of our institute, and said, we hear that you're providing this kind of training. We're looking for people who have exactly this kind of skill set, and we can't find anybody. Do you have someone? This young woman was somebody who had that skill set because she came through our program. And we have lots of other stories like that of recent graduates who, because they not only know how to practice law in the traditional way, but they are supplementing that knowledge with new ideas, new skills that will make them more competitive no matter what career they may choose. So, that is the future of the legal profession as I see it, innovation and technology. One last note, because this is a legal ethics lecture, I think by definition, I want to talk a little bit about regulation. And in particular, what the future of legal services regulation should look like in light of this emerging new reality. If you go back 40 years or so ago, you saw the birth of something called the law of lawyering. And the institute, Monroe Friedman Institute. Monroe Friedman was a leader, a pioneer in this area of developing the law of lawyering. And since that time, it has become a really robust area with many different features governing what lawyers do. So here's a chart that may help you understand the basic point I'm going to make. Here's the law of lawyering over on the left side. That is the law governing what lawyers do. Rules of professional conduct are one obvious example of law that governs lawyers' behavior. Malpractice law, tort law, can govern lawyers' behavior. Rules of civil procedure, to some extent, Rule 11 and other kinds of rules govern lawyers' behavior. There are administrative regulations, Sarbanes-Oxley, IRS regulations that have some provisions that are directly targeted at lawyer behavior. This is the law of lawyering. But in light of the emerging reality of all of these new players in the industry, some of them I've already referenced, we need to think more broadly about the regulation of legal services, more broadly about what legal ethics actually is. Legal ethics can't just be about lawyers anymore. We need to think about all of the other new service providers. And so this category, in an article I recently wrote, suggests that we need a law of other legal service providers and that we need to conceptualize this whole area more broadly as the law of legal services. And under that umbrella includes the law of lawyering, but these other kinds of law as well. And there are two different subparts to this law of other legal services providers. There are court-authorized and regulated, and then there are market-created new players. And I just want to talk briefly about those two categories. So let me start with court-authorized and regulated. And actually, before I dive into that, I want to ask a different question. Why is this shift important? One I've already alluded to, but I want to talk briefly about the second, because Ellen also mentioned the important role of access to justice in a lot of the work that I've been doing and that we should all be doing. So first of all, the shift in regulatory thinking is important. First, because of the sheer number and growing number of other kinds of legal services providers, we need a regulatory framework for thinking about what they do, for appropriately regulating what they do. But secondly, and even more importantly, because when I pose that first question, people sometimes say, well, why should other people who are not lawyers, be allowed to deliver legal services at all? Why is that not just the unauthorized practice of law? So I want to make the case for you that other legal services providers should exist alongside lawyers, and the two are not mutually exclusive. Why do I think these other kinds of legal services providers should exist? The reason I think that is for a few different reasons. Primary among them is that there's an enormous access to justice gap in this country. We know that 80% of the legal needs of the poor go unmet. We know that in a significant number of courts around the country, a vast majority of people who show up there do not have lawyers. They're representing themselves pro se. There's a huge problem with people not getting access to the legal services that they need. And the lawyer-based solutions that people have been proposing for decades are simply not enough. Here are the three lawyer-based solutions that people have advocated for. Number one, civil Gideon. So you're familiar with Gideon versus Wainwright, the idea that you have the right to a lawyer in a criminal proceeding where you're facing potential jail time. People made the case, well, there are lots of other legal issues that people may confront that are almost as equally important, and and they deserve representation in those contexts as well. It's called the Civil Gideon movement. And there has been some progress, but not nearly enough to ensure that everybody has access to the legal services that they need. Other people have said, well, we just need to advocate Congress to increase funding for civil legal aid. Well, I don't know, you may have a different view, but right now there's a proposal to actually eliminate the Legal Services Corporation, which is the primary source of funds for legal services at the federal level. I am not at all optimistic that we're going to see increases in funding for civil legal aid. Other people have argued, well, lawyers just need to do more pro bono work. Lawyers are already facing incredible competitive threats. The idea that they should ramp up their pro bono work, well, wonderful, it's a great idea, it's very unlikely. Moreover, in order to meet the need of the American public in terms of their legal services, lawyers would have to perform, each and every lawyer would have to perform something, I think, in the order of 250 to 300 pro bono hours a year. It's just not going to happen. It's not realistic. So, what do we do? How do we approach this issue, given that the traditional solutions are not cutting it? I think the two, court-authorized and regulated legal services providers, and embracing but appropriately regulating new market-based solutions is the way to go. So coming back to my diagram, I'm talking here about court-authorized and regulated. Just to give you a couple of examples, triple LTs, they're called limited licensed legal technicians. They exist in Washington State. It took them about 14 years to make it happen because there was so much resistance to it. And the idea behind it is they are people who have gotten very specialized training, thousands of hours of training in a very particular area. In Washington, it's family law. And they are allowed to deliver legal services in family law. And they are considered lawyers for purposes of that type of service. So that is regulated by the court in Washington State. All sorts, they are subject to the rules of professional conduct that look almost exactly the same as they do for lawyers. So that's one solution. More modest are courthouse navigators. So you can go into a courthouse, and you have this in New York, where you can go, somebody will be there and help guide you to the information you need. And those are regulated by courts. You've got document preparers in some jurisdictions, people who are allowed to help you prepare legal documents, but they are constrained in terms of what they can do. Again, regulated by courts. At the same time, we also have market, and let me just talk about this recommendation from the ABA Commission on the Future of Legal Services, endorse the idea that courts should be looking at these new kinds of legal services providers, and if they determine that they are beneficial to the public, should be adopting them. So it was an important finding, and if people have more interest, I can tell you a little bit more about the process that led to that recommendation. And then we have market-based solutions. So the market-based solutions are, there are some that are entity-facing, that is services that are delivered to, for example, in-house legal counsel or law firms, and then there are some that are public-facing. And the classic example here would be Legalzoom, but you could also think of AVO. For those of you who have seen AVO, they provide legal information to the public. They're also into the marketing arena for lawyers. What do we do about them? Well, the typical reaction has been binary. And what I mean by that is states have gone in one of two directions. They've either tried to shut them down. So Legalzoom has been subject to unauthorized practice of law litigation in a number of states. Legalzoom has won every single case. Sometimes they've had to make a few changes here or there, but they are permitted to operate everywhere. So that has not proven to be a particularly wise approach or an effective approach. Other jurisdictions have just said, well, we're not going to do anything about Legalzoom. We're just going to let consumer protection provisions govern. That seems to me to be underappreciating the kind of services that a company like Legalzoom may provide. So I think there may be a third way, and that third way is what a professor named Gillian Hatfield has called right regulation. The idea of thinking about regulating in a meaningful way these new kinds of legal services providers. And what this means is liberalizing the marketplace for legal services does not mean deregulating. We can provide appropriate regulation. We can embrace these new providers and appropriately regulate them at the same time. And the Commission on the Future of Legal Services essentially reached the same conclusion and suggested that any new regulations in this area should be governed by what are called model regulatory objectives for the provision of legal services. These are brand new, within the last couple of years, listing what are the relevant considerations when we are thinking about new kinds of regulation. Nowhere in this list will you see protection of lawyers as one of the objectives. That was quite intentional. The idea is that it's about the protection of the public, and we should be regulating companies like Legalzoom and other competitors with the public at the forefront of our mind. Now, this is a threat to lawyers. I care very deeply about the future of lawyers and my own graduates, and I'm sure you all do too. But when we're thinking about regulation, we need to be, especially because we self-regulate, we need to be thinking about what is best for the public that we are all privileged to serve. And so these principles, I think, are really important to follow. Okay. Are there any other regulatory innovations? I'll just mention one, and then I'll close. There is a recommendation from the Commission on the Future of Legal Services that states should continue to explore what are called alternative business structures. So rather than thinking about lawyers over here and other legal services providers over here, why don't we allow them to work together more readily? And for those of you who have taken professional responsibility, you know that in the United States, there are severe limitations on our ability to do that. Rule 5.4 of the Rules of Professional Conduct prohibits lawyers from sharing fees with people who are not lawyers. And this dramatically limits the ability of law firms to bring on as partners or as equity investors people who want to help law firms innovate, to compete with the Legalzooms of the world. This puts us at a competitive disadvantage, and I think Rule 5.5 or Rule 5.4 is not doing law firms a great service, and it's not doing our clients a great service. And one of the recommendations was continued exploration of this idea of eliminating that wall and allowing lawyers and people who are not lawyers to work more closely together. So what's the bottom line? I hope I'm leaving you with the message that we need to think in new ways. We need to think in new ways about how we deliver legal services. We need to think in new ways about how we regulate legal services. This is about our future as a legal industry. I think if we don't embrace these changes, we are going to see regulation taken away from us, as has been the case in other parts of the world. The UK had regulation taken away from it. I think we as a profession need to focus on making sure that we are doing whatever we can to aid our clients and the public. And I think innovation, both in legal services delivery and regulation, is the way to go. So thank you very much. I look forward to getting your questions. Questions? Oh, I thought it was my mom's hand. It's not. Jen.
Really? What are you saying about my...
I know you were very close to her, so I wasn't sure.
And I noticed I wasn't the one who taught you. I'm the one who was a colleague, so that puts me, I guess, a little bit. Anyway, so as a dean, have you put your dean hat on for a minute. What do you do, given that faculty grew up in an age of the Langdellian method of teaching, and probably very few had any exposure to a lot of what you were talking about as far as the disruption of the legal profession. And so what do you do with faculty who need to get on board with training students for the next generation of the profession when they are themselves not part of that next generation?
Well, this is being recorded, so I'm going to be careful in how I answer that question. I consider myself one of those people. So when I was in law school, the big innovation is that people had laptops in the classroom, and there was this big disruption, this idea that people were tapping on keys, and oh my goodness, this is so distracting. So it's not like I came of age at a time when all this innovation was taking place. I didn't, but I invested the time and energy to learn, because I think as law faculty, we have an obligation to our students to make sure that we are as aware as possible about what's going on in the marketplace. Now, will everyone do that? I'm realistic to know that the answer is no. So what can a law school do? Again, putting on a dean's hat. I can tell you what we did at Suffolk. When we created the institute and we created a concentration, the idea behind it is what I would call a parallel track of disruption. That is, we had all of these courses. We were not requiring faculty to do anything different. If they wanted to participate, great. We had various courses that they could teach, but we weren't asking them to do anything new. We were building these courses, and if law students wanted to take them, wonderful. And we were fortunate enough to be in a location right in downtown Boston that has a huge number of innovators we could draw on to teach those courses as adjuncts. And we had enough members of the faculty who were willing to participate that we have been able to create a robust program. So at least initially, I think that's the way to go about it. I think over time, as these changes are taking place, more and more faculty will embrace them. But for now, that's how I think a law school can go about it. Yes?
What do you think of the concept of unbundling legal services? You've been on the bespoke end, you've been on the it's done, and what about the concept of separating services based on consumer choice?
Yeah, so unbundling, I think, is a concept that, from my perspective, is a no-brainer, and I think should be permissible. I mean, it needs to be carefully structured to protect client interests, but the concept of unbundling, this idea that a lawyer should not feel obligated when a client comes in to handle the entire matter and might be able to handle a discrete matter for the client and the client can handle the rest on his or her own, I think is a very important development and one that does move the needle a bit on access to justice. It doesn't come remotely close to solving the problem, but I do think from an ethical perspective should be allowed, and in most jurisdictions these days is allowed. Yes?
I just wonder if you could explore, do you think not everyone thinks innovation in this new, millennially or generationally is a good thing, something is lost in competition, per se, right? So I wonder if you could discuss what is lost in shifting from the traditional Hegelian model of teaching as well as sending folks out and piecemealing legal services towards innovation.
Yeah. So there are a number of arguments against this trend, and they turn on ought questions. Ought we be doing this? The reality is happening, right? So we could either resist it or be a part of it. But let's ask the question, is this all a good thing? And is something lost? I do think something is lost to a certain degree. The biggest argument that I've heard against many of these developments is that this one lawyer, one client, the bespoke legal services is so valuable. Clients really do benefit. If they have a competent lawyer representing them, that is the ideal solution. That is wonderful if you can get somebody to do that work for you. Some of the most important legal work ever done in our nation has been the cause of that very important relationship. And I'm not suggesting that we should never have it. I'm suggesting that there are so many people who will never have the opportunity to have that kind of relationship that we need to help them too. And innovation is really, in my view, the only way to accomplish that goal. So I don't want to see the bespoke model or the lawyer-client relationship disappear. There's still a role for it, but I think we need to supplement it if we are really going to serve the public the way that I think we have an obligation to do. Yes?
You started off by blaming the law schools. And then your blame, if I maybe you didn't mean to say it that wrongly, but what you blamed them for was the way that lawyers are being taught or being trained. But isn't there another aspect to it? When you threw out the graphs or charts, and everything on the right are things that are provided by non-lawyers, technology or other professionals and so on. Maybe one of the things that the law schools are responsible about is not cutting down on the number of students that we're training as traditional lawyers. Or at least, over the last however many years, putting aside the last couple when the market has changed, the number of law schools and the number of law students has greatly expanded. And so you're taking people into a profession where arguably there are not in the future going to be as many traditional lawyer jobs. Don't we bear some blame in that regard?
So I completely agree with you that there will be a need for fewer lawyers in the future relative to the number of lawyers we needed 10 years ago. And law schools have an obligation to reduce the number of people they are taking in and graduating. The reality is that we have adjusted. So over the last 7 to 8 years, law schools across the country have brought in 30% fewer first-year students than they were bringing in at the same point 7 or 8 years ago. That's a pretty remarkable and dramatic drop. My own law school had dropped, I think, 35%. Because we feel that we have an obligation to make sure that the people we are admitting, sure, there's been a decline in applications, true, and that has driven a lot of it. But I do think what we've seen over that same period of time are all of these innovations that are going to make it harder for lawyers in the future, and that we won't be as much of a need for that large a number. Now, I think in the future, this 30% reduction, is that going to be the right number? I think we could debate that. And I've recently put up a blog post analyzing whether that's the right number, and it's very, very difficult to predict with great certainty, as it always is, about just what the demand is going to be. So if you Google my name, Perlman, Future of Legal Education, you'll see my analysis in more detail. But I think the 30% decline is, in fact, responding to this development. And if we hadn't done that, I think that would be another area for law school blame. Yes?
Somewhat related to that question, very few people grow up looking to deliver bundled legal services. And if they want to help people, they're going to come to law school. But should law schools be looking at it differently and marketing themselves to those who are out there looking for tech jobs or something and saying, here's a place for your name in law school to come learn about the law, but also learn the technology and take that out?
Yes. Yes, and yes. So so we market ourselves that way. We want to get people who are technologically inclined. We think they will be in a particularly good position. There will be fewer jobs for lawyers. Are going to be in the best position to succeed. So we're marketing ourselves that way, and some other law schools are as well. In terms of what people imagine that they're going to do, yes, we want to help people. But I want to help as many people as possible. If I'm a lawyer, the one-on-one bespoke relationship, sure, that's helping people. But if I can help 10 people, but maybe don't have the bespoke relationship, and those other 9 people that I'm helping might not otherwise have had a lawyer, I'm feeling pretty good about that. And the only way that I can accomplish that and still have a financially sustainable law practice is if I come up with ways to become more efficient. So I think that what I'm suggesting is very consistent with the idea of lawyers who come to law school with the vision of helping people. I think you can actually help people more effectively if you embrace these concepts. Yes?
You spoke about court-authorized and regulated non-lawyers providing legal services. Does that at all have any impact on a defendant's appeal that the leading ineffective legal counsel, and how does that affect that?
So, yeah, sure. The question was, in this court-authorized and regulated legal service providers, how might that affect people who argue that they've received ineffective assistance of counsel? And the implication of the question is that you're talking about criminal law. And these new areas for people who are not lawyers, they're not used for criminal law matters, because as a constitutional matter, you could not do that. So that would be the answer to the question. I think that there are certain areas, criminal law is a good example, where you can't look to people who are not lawyers. And if you notice, I keep using the phrase people who are not lawyers as opposed to non-lawyers. It's very deliberate. There's a lot of criticism out there of lawyers using the phrase non-lawyers. You never hear doctors talk about non-doctors or accountants saying non-accountants. And it creates, and I'm not criticizing you in any way, because several people have used the phrase non-lawyers. But it's interesting that we use that phrasing because we view ourselves as really different from other people in terms of what they can do. I think we need a really conceptual shift, much like the medical profession has gone through a shift in thinking about healthcare services. Sure, doctors are important, but there are an array of other professional service providers who support what doctors do. Right? You can go to a Minute Clinic, you can get all kinds of healthcare services without seeing a doctor. I think we need to think exactly like that in the context of law. Yes?
I don't think you can quite get away from that question.
Okay.
What about malpractice? What if, suing for malpractice in a civil claim? And that's probably an answer to that too.
Right. Yeah. So I'll use the example of limited license legal technicians in Washington. What's interesting about that program is Washington State requires limited license legal technicians to have malpractice insurance. Now, what's interesting about that is how many states in the country require lawyers to have malpractice insurance? Anybody know the answer? One. One state in the country requires lawyers to have malpractice insurance. So if we are genuine in our concern that clients and the public are protected from people who are practicing without malpractice insurance, we better look at ourselves, because we don't require it of lawyers except in Oregon. So these new providers, at the very least in Washington State, the limited licensed legal technicians, if you're concerned about malpractice, if you're an ordinary member of the public, you're better off going to the LLT than to the lawyer from a malpractice perspective. Much more likely the person will have malpractice insurance. So I agree with you, it's an important consideration, but there are regulatory ways around it, and we also need to think about doing it for ourselves if we really want to take that concern seriously.
Okay, good. Well, I was going to say it's time for you to stop. So thank you so much. Really terrific.